at 8:45. We'll begin meeting number 4 of the Standing Committee on Justice and Human Rights.
Okay, thanks.
And today, pursuant to the order of reference of Wednesday, September the 28th, 2011, Bill C-10, an act to enact the Justice for Victims of Terrorism Act and to amend the State Immunity Act, the Criminal Code, the Controlled Drugs and Substances Act, the Corrections and Conditional Release Act, the Youth Criminal Justice Act, the Immigration and Refugee Protection Act, and other acts. And today, appearing is the Honourable Rob Nicholson, Minister of Justice, and the Honourable Vic Toews, Minister of Public Safety, along with their officials and ministers. The agreed process today has been that each of you will be given 5 minutes as an opening address, and then we'll go to questions from the panel.
Well, thank you very much. I'm pleased to be here with Catherine Kane from the Department of Justice, who I think you know very well from all the different pieces of legislation that we've had. Je suis heureux de m'adresser aux membres.
I'm pleased to have the opportunity to appear before the committee in your study of Bill C-10, an act to ensure the Justice of Victims Terrorism Act and safe streets and communities.
Our government's commitment to quickly reintroduce legislation to combat crime and stand up for victims and law-abiding Canadians. Canadians, as you know, gave us a strong mandate to bring forward these measures that will better protect society and ensure that criminals are held accountable for their actions. C-10 combines 9 bills that were not passed in the previous Parliament, all of which have been debated in both the House of Commons and/or the Senate. I am pleased today to be joined by my colleague, the Honourable Vic Toews, Minister of Safety, to outline the important measures contained in this bill. I will speak to parts 2 and 4 of the bill. Minister Toews will speak to parts 1 and 3 of the bill. As I previously stated, while the text of C-10 is certainly longer than most, the fact remains that these reforms have been debated, studied, and in some cases passed by at least one chamber. I encourage all members of the committee to consult the parliamentary record that exists for all of these previous bills. I'll take a few moments to highlight a number of the measures. Part 2 of the Safe Streets and Communities Act includes former Bill S-10, the Penalties for Organized Drug Crime Act. As you may know, it proposes to amend the Controlled Drugs and Substances Act to impose mandatory penalties for the offences of production, trafficking, or possession for the purposes of trafficking or importing, and exporting or possession for the purposes of exporting a Schedule I drug such as heroin, cocaine, methamphetamine, and Schedule II drugs such as marijuana. As you may be aware, this is the 4th time that this bill has been introduced. They have been passed by both chambers, but obviously never by both in the same session. This bill is in exactly the same form as it was in the dissolution of the last Parliament. Part 2 also includes reforms previously proposed by the former Bill C-16, the Ending House Arrest for Property and Other Serious Crimes by Serious and Violent Offenders Act. These reforms would explicitly state that a conditional sentence is never available for offences punishable by a maximum of 14 years or life, for offences prosecuted by indictment and punishable by a maximum penalty of 10 years that result in bodily harm, involve the import, export, trafficking, and production of drugs, or involve the use of a weapon, or for the listed property and violent offences punishable by 10 years and prosecuted by indictments such as criminal harassment, trafficking in persons, and theft over $5,000. Now, this is the 3rd time these reforms have been introduced by our government, and on each prior occasion they received second reading approval in principle and scope. I note that there have been a few technical changes made to the list of excluded offences punishable by a maximum of 10 years. These include changes to include the recently enacted new offence of motor vehicle theft, to coordinate the proposed imposition of a mandatory sentence of imprisonment in Section 172.1, the luring of a child, with the conditional sentences amendments. Now, the last component of Part 2 are the reforms previously proposed by Bill C-54, Protecting Children from Sexual Predators Act. These reforms seek to consistently and adequately condemn all forms of child sexual abuse through the imposition of new and higher mandatory penalties. They also seek to prevent the commission of sexual offenses against children through the creation of 2 new offenses. We are also seeking to require the courts to consider imposing conditions to prevent suspected or convicted child sex offenders from engaging in conduct that could facilitate or further a sexual offense against a child. While Bill C-54 had been passed by the House of Commons with an all-party support, and it was at third reading debate in the Senate when, unfortunately, the opposition parties decided to force an election, and I was very disappointed that this important bill then died on the order paper. But since that time, we've made some changes, as you will see, to increase the maximum penalties with a corresponding increase in mandatory minimum sentences to better reflect the nature of the offenses, including making or distributing child pornography or parent or guardian procuring their child for unlawful sexual activity. And these changes are consistent with the government's objectives for the former Bill C-54. As well as the 2 new sexual offenses proposed by this part would be added to Schedule 1 of the Criminal Records Act to ensure that persons convicted of either offense are subject to the same period of ineligibility for a record suspension, currently referred to as a pardon, as for other child sexual offenses. Finally, Part 4 of the bill proposes to amend the Youth Criminal Justice Act to strengthen the way the system deals with violent and repeat young offenders. Now, these measures include highlighting protection of the public as a principle, making it easier to detain youth charged with serious offenses pending trial, ensuring that prosecutors consider seeking adult sentences for the most serious offenses, requiring police to keep records of extrajudicial measures, and requiring courts to lift the publication ban of the names of young offenders convicted of violent offenses when a youth sentence is given. These reforms were previously proposed in Bill C-4, Sebastian's Law. The former C-4 was extensively studied by the House of Commons Standing Committee through 16 meetings at the dissolution of the previous Parliament. The bill includes changes to address concerns that have been highlighted by the provinces regarding the pretrial adult sentencing and deferred custody provisions in the bill. For example, changes to the pretrial detention provisions respond to the province's requests for more flexibility to detain youth who are spiraling out of control and pose a risk to the public of committing a serious offense if released, even if they have not been charged initially with a serious offense. The test for pretrial detention would now be self-contained in the Act without requiring reference to the criminal code, which is currently the case. Other technical changes include removing the proposed test for an adult sentence and deferred custody and supervision orders and returning to the current law's approach. For example, the former bill referred to the standard of beyond a reasonable doubt, while some provinces found more difficult to meet. That has been removed and continues the current approach of leaving it up to the courts to determine the appropriate standard of proof. Under C-10, deferred custody and supervision orders will not be available if the youth has been found guilty of an offense involving or attempting to cause serious bodily harm. In closing, most of C-10's reforms have been debated, studied, and some even passed. The few new elements I've outlined are consistent with the objectives of the former bills as originally introduced or make some needed technical changes. I urge the committee to work with the government to support the timely enactment of the Safe Streets and Communities Act. And We are taking action to protect families, stand up for victims, and hold individuals accountable. Canadians can count on our government's commitment to fulfill its promise to pass this comprehensive bill within the first 100 sitting days of this Parliament. Thank you very much. I would ask Minister Toews now to deliver his remarks.
Thank you, Minister Nicholson, and Mr. Chairman, honourable members of the committee. I would like to thank you for the invitation to be here and for the opportunity to speak with you on Bill C-10, the Safe Streets and Communities Act. With me is Mary Campbell of the Department. Today I would like to focus my opening remarks on components of the legislation before you which do pertain to the public safety portfolio. These provisions will eliminate pardons for serious crimes. It will increase offender accountability and support victims of crime. It will provide justice for victims of terrorism and ensure public safety is the paramount consideration when considering offenders' requests for an international transfer. Last year, our government passed legislation to initiate reforms to the pardon system, and Bill C-10 contains further measures to eliminate pardons for serious crimes, including sexual offences against minors. Bill C-10 will also replace the word pardon with the more appropriate term record suspension, and further stipulates that an individual convicted of more than 3 indictable offences who has received a sentence of 2 years or more for each will be ineligible for a record suspension. These reforms to the pardons system will also apply to the equivalent service offences under the National Defence Act. Bill C-10 would also enshrine in law a victim's right to attend and make statements at parole hearings. In addition, it would enable victims to request additional information about an offender, including the reason for transfer or temporary absence and an offender's participation in program activities. This bill proposes that when offenders withdraw 14 days or less before the date of a hearing, the parole board may proceed as scheduled. Victims would also have the right to ask why the offender has waived a parole hearing. These measures would go a long way to preserving the peace of mind of victims. Bill C-10 would also modernize the system of discipline in federal penitentiary. It will address disrespectful, intimidating, or assaultive behavior, including throwing of bodily substances. It would also restrict visits for inmates who have been segregated for serious disciplinary offences. Our frontline officers have asked for these measures, and we are proud to deliver. This government is committed to transforming our corrections system to ensure that it actually corrects. We have already taken major steps to address the recommendations contained in the roadmap to public safety. The bill before the House continues this vital work. Canadians deserve to feel safe in their homes. Victims deserve to be treated with more respect. Corrections officers need the tools to do their jobs, and offenders must be prepared to take more responsibility for their conduct and pay the price if they break the rules. C-10 will do all that. Bill C-10 will do a lot for victims, including victims of terrorist attacks. Specifically, Bill C-10 will allow victims of terrorism to sue in a Canadian court perpetrators of terrorist acts and their supporters if the victims can demonstrate a real and substantial connection between their actions in Canada. In addition, an action could be brought against individuals, entities, or listed states which provided support to a listed entity. These provisions are retroactive to January 1st, 1985 in order to allow victims of terrorism to seek redress for loss and damage that occurred as a result of a terrorist act committed anywhere in the world on or after that date. Finally, Bill C-10 will further strengthen our efforts to build safer streets and communities for all Canadians by amending the International Transfer of Offenders Act. These amendments would ensure in law a number of additional key factors that may be taken into account in decisions respecting whether or not an offender serving a sentence overseas or indeed south of the line should be granted a transfer back to Canada. This would include consideration of the safety of any person in Canada who is a victim or a member of the offender's family. Another consideration would be whether the offender would continue to engage in criminal activities following the transfer or endanger the safety of a child, particularly in cases of offenders who have been convicted of sexual abuse. Our government believes that protection of society must be the paramount concern of our justice system, and with the Safe Streets and Communities Act, we are ensuring that law-abiding citizens and families are protected, criminals are held accountable, victims are heard and respected, and we have a correction system that actually corrects. As you know, Canadians gave our government a strong mandate to keep our streets and communities safe. With the Safe Streets and Communities Act, that is exactly what we are continuing to do. Thank you, and I would be happy to answer any questions that you may wish to direct to me. Thank you.
Thank you to both the ministers, and now we begin the rounds. They are 5-minute rounds. 5 minutes is the question and the answer, and I will cut it off in mid-word if necessary to be fair to everybody. So first is Mr. Gauguin from the
Thank you, Mr. Chair. My question would be to Minister Nicholson.
I'm sorry. My mistake. Mr. Comartin is first from the NDP.
I have to say, Mr. Chair, I know your government wants to rush this thing through, but we do have to follow the rules, and I get to go first, or my side gets to go first. Thank you, Mr. Ministers, both for being here. I'd like to start, Mr. Nicholson, with you, if I could. You have a study which you refer to constantly on costs of crime in this country. My first question is, was that commissioned by your department?
I believe it was the Department of Justice put that out.
Okay,
You're referring to the one that the cost of crime is approximately $99 billion. It's a 2008 Department of Justice, and indicating most of the costs are borne by victims.
That was commissioned back in 2008?
Yes, it is.
All right. And the author of this?
It's done internally by the Department of Justice.
Okay. And so the author is a member of the Department of Justice?
Department of Justice.
Staff. Did you at the same time commission a study on the costs of any of these bills as they were then individual bills, and in particular the drug bill?
Again, we consult on a regular basis with our colleagues. The Department of Justice, as you know, works with our provincial counterparts, and we have had discussions, of course, with public safety, because ultimately, if an individual is being detained because they are a drug dealer, these can increase the costs to the correctional system.
Do you have any figures as to how much, just the drug part of this bill, the increased incarceration under the drug bill is going to cost the federal treasury?
By all means, that approximately about $68 million over the next 5 years would be the cost of that particular section of the bill.
Is there an actual study, an analysis, a written analysis of that figure, for that figure?
Yeah, it was again disclosed as part of the Bryson motion earlier in the spring, and again, this results from our consultations, within the department and the public safety department.
Has there been any similar analysis been done as to the cost, again, just of the drug part of this bill, to the provincial and territorial governments?
Not undertaken by the Department of Justice, but I've had discussions, of course, over the years, so they're well aware of all the provisions of this. And again, I very much appreciate the support that we have received from my provincial counterparts moving forward on this.
But the question, Mr. Nicholson, was, has an actual analysis been done of what it is going to cost the provinces and territories?
The analysis that we have is what it's going to cost the federal government. The federal government prosecutes, for the most part, the offenses contained therein, and if you're detained, as you know, for 2 years or more, you're detained within federal facilities, but we don't have a breakdown of what the possible costs are for each province or territory.
Has an analysis been made of the proportion of people convicted, newly convicted under the drug part of this bill, who will go into provincial institutions as opposed to federal institutions?
No, you can see the mandatory minimums will push more people into the federal system, and so you're right. It'll be a reduction in that sense. That the people who get increased penalties are more likely to end up in federal institutions. So you're quite correct. It might ease some of the pressure on provincial facilities.
I don't want to leave the impression that I'm agreeing with that comment.
Oh, I'm sorry. I thought that was the
Mr.
direction
Minister,
you were going.
My analysis is just the opposite.
Oh, I
that we're
see.
going to
Well,
see a
that's fair
huge increase in the number of prisoners at the provincial institution because of the 2 years less.
Well, we'll have to take some comfort. We're getting the right ones in there, Mr. Comartin.
Again, I'll disagree with you on that. If I can switch to, I'm sorry, just one more question with regards to provincial costs. Are you aware of any of the provinces having done an analysis, again, just on the drug part of the bill, as to how much it's going to cost them individually?
I don't know any specifically. I noticed just recently the Saskatchewan Minister of Corrections indicating that it's very difficult to try and predict the increased costs or costs into the future, and trying to determine what people's behavior would be. I guess, again, they can speak for themselves, but it's very difficult.
If a provincial government was going to do that analysis and required information and data from yourself or Minister Tave's department, would you be willing to give them that information?
We try to help them in every possible way, Mr. Comartin, and as I say, with the drug bill, this is the 4th time we've introduced it, and quite frankly, I've had discussions going back now almost 5 years with my provincial counterparts, so they're well aware of the implications, and again, I'm very grateful for all the support that they've given over the years.
Mr. Comartin. Now, Mr. Gauguin.
Thank you, Mr. Chair. Question to Minister Nicholson, and where he's concise in his answers, I'll probably pass the baton to my friend, Mr. Seaback.
I'm concise in my answers?
I said no. You're most usually concise.
Oh, okay. Thank you. Yes, I just wanted a clarification on that.
Minister, the opposition parties and the media have stated that this government is going after individuals who are growing the 6 plants in their homes for personal use. Is this the intent of Bill C-10? Is this what Bill C-10 does? Is this bill imposing mandatory minimum penalties for the individual who is recreationally using drugs or the addict that can't wean himself off drugs?
No, I appreciate our critics want to spin this in a way to give that impression, and you'll hear this from people who don't want us to go after people who are in the business of trafficking. But the bill is very clear that if you are in the grow-op business and you have between 6 and 199 plants, you will come within the provisions of this if you're in the business of trafficking. And again, our critics, for whatever reason, I suppose they can explain that themselves, generally forget to mention that. But that is an essential element of the offense. And again, the whole problem with grow-ops, I hear about this everywhere I go in the country. I hear about it from law enforcement agencies. I hear it from firefighters, that it is a growing health and safety problem. And again, I've indicated to them that we are doing our very best to move forward in this direction, to send out the right message that this kind of activity for the purposes of trafficking is not tolerable. That being said, for the individual who has either unfortunately become addicted or is experimenting, through the National Anti-Drug Strategy, we try and get the message out to encourage people not to get involved with this kind of activity, and certainly we want to help those individuals who have unfortunately become addicted. That being said, this bill is very specific. It goes after those individuals who are in the business of selling and distributing and producing drugs. It takes aim at organized crime, because that's who law enforcement agencies tell me. These are the people bringing drugs into this country. It's not some individual acting on his own. They tell me it's organized crime that moves drugs in and out of Canada, and so this bill is very specifically and it targets those individuals.
Thank you, Minister. I'll pass the baton, with your permission, to Mr. Seaback. Share my time.
A little over 2 minutes.
Great, thank you. Mr. Nicholson, one of the things that I've noticed when I meet and talk with my constituents is that they seem frustrated with the system. They've been frustrated that violent offenders are receiving sentences like house arrest. I'm wondering if you could perhaps expand upon what you've said earlier, how this is going to help restore faith in the justice system and ensure that violent criminal offenders are not receiving conditional sentences and are back in our communities.
Well, we've had, at this point in time, a fairly long history with containing the use of conditional sentences, or very often referred to as house arrest. In fact, my colleague introduced the first bill on behalf of this government to limit house arrest, and I always remember the quip he had that if somebody sets fire to your house, he shouldn't be qualified to go home to his house after he or she has been convicted. So I think you said that, didn't you, Public Safety Minister? In any case, as you can see by the bill before you, the bill is very specific, so that the most serious offenses within the criminal code, you will not be eligible to go home afterwards, that there is and will continue, of course, to be serious consequences. And again, I think this helps people's confidence in the criminal justice system. We all have a stake in that, and in seeing that people have confidence in our justice system and in our political system. And so I believe this is a step in the right direction. And again, the changes that we have made and are proposing to clarify the provisions with respect to conditional sentencing are contained in this bill, and they're an important component of what we're proposing.
Got 10 seconds.
Thank you very much.
Okay. Thank you. Mr. Kotler?
Thank you, Mr. Chairman. I also want to welcome our two witnesses this morning. Both of you have mentioned that Canadians have given us a strong mandate for safe streets and communities. That is correct. But Canadians give every government a strong mandate for safe streets and communities. And indeed, governments have an obligation to protect their citizens. So the question really then becomes, how do governments go about doing this? Now, even before this legislation was tabled, we had a serious problem with prison overcrowding. And indeed, in some provinces, it had reached 200%. Recently, the United States Supreme Court said that a threshold of 137% above that in prison overcrowding would lead to cruel and unusual punishment. How do you address this question? Because if we had a serious problem before this legislation, that problem may be exacerbated by the legislation. And how will the provinces on whom this is going to be offloaded be able to deal with this?
Well, maybe I can try to answer part of that question. Of course, the American system is very, very different. The federal system in the United States doesn't have even a parole system, and so there is no mechanism to relieve any pressure through that. So the courts had to make a very arbitrary decision in that respect. I believe in the federal system in the United States, you serve 85% of your sentence and you get 15% off for good behavior, but there's no parole system. The idea that somehow, and I can speak from the federal point of view, that the legislation that we brought forward is causing overcrowding, I think is mistaken. At the beginning of 2010, we had approximately 14,000 prisoners in the federal system with a capacity of 15,000. My staff advised me that, or I should say officials advised me, that there would be an increase of prisoners to 16,200 by September of this year. In fact, the number is 14,800. So they underestimated the amount of prisoners coming into the system or remaining in the system by about 2/3. At the same time, we authorized the construction of 2,500 units in existing prisons, so new units in existing prisons to accommodate any additional prisoners that might come. To date, those have not been constructed and have not. It hasn't been necessary to utilize them, although I can say that the prison officials have to be creative in terms of moving individuals because of the pressures of gangs and the like. So these 2,500 units that we have authorized that are coming online in the next couple of years will be necessary to ease some of those pressures and also to create flexibility in terms of some of the gang problems that we have inside prisons.
Mr. Chairman, for reasons of time, I'm just going to turn to another issue. And since I'm in dialogue with Mr. Toews, I'll put this question directly to him. You've referenced an important piece of legislation that has not been taken particular note of in this bill, and I'm referring here to the proposed amendments respecting the State Immunity Act, which will give Canadians a civil remedy against their foreign terrorist perpetrators. Now, the legislation that you have proposed provides for a listing mechanism. The government and council will list the countries against whom such a civil remedy can be invoked. Now, as you know, there have been private members' bills that have offered other approaches as alternatives to a listing mechanism for, I think, some of the reasons you know. But in particular, a witness that the government called upon in earlier debates on this matter, Victor Compras from the United States, supported the principle of a civil remedy, as I do. With respect to the listing mechanism, said, and I believe I'm quoting him directly, "Don't go there, we made a mistake." So my question to you is, are you prepared to consider other alternatives, or can you give me the justification in that context for the listing mechanism?
Well, Mr. Cockler, I do respect your opinion very much. As a result of our conversation, I spoke with officials and I said, look, is it justified that we look at some alterations here? The officials basically stated that they believe this was the best way to proceed, but I would encourage you to interview those officials to have that discussion, and perhaps, I don't know if there's any flexibility. We've discussed both sides of that issue. I think we both want exactly the same thing, justice for victims of terrorism, and certainly I know that I'm willing to consider arguments, but this is where officials advise us is the best route at this point.
Ms. Finley?
Thank you, Mr. Chair. My question is for Minister Nicholson. I believe that all honourable members here wish to do everything possible to protect our children from harm. As a parent myself, it's certainly a great fear of mine any time that I hear that a child has been hurt or could be. Children are particularly vulnerable to sexual abuse and exploitation and are, in fact, as I understand it, the majority of victims of all police-reported victims of sexual assault in Canada. Children represented 59% of all police-reported sexual assault victims, which I believe is about 13,700 children under the age of 18 in 2008 alone. My source for that is StatsCan Centre for Justice Statistics, the Uniform Crime Reporting Survey. Minister, is there a risk that implementing mandatory minimum penalties might result in more plea bargaining?
One of the things that you will notice is that the bill is comprehensive in the sense it covers a whole range of sexual assaults or offenses against children, and it's designed for, among other reasons, to make sure that an individual that's in the business of molesting children or abusing children does not escape the penalties that are within the criminal code. In addition, it goes beyond the existing offenses because we know that we have to continuously analyze what takes place in this type of activity, and this is why we've included two new offenses. That while it is an offense for an individual to lure a child over the internet to set that child up to be sexually exploited. It currently is not covered in the criminal code, where two adults discuss this among themselves on how to do that. So that is one of the changes that we have made. The other change that we have made, and again this is in response to problems that we have heard, is that we are making it an offense for somebody to give sexually explicit material to a child for the purpose of grooming that child, setting that child up in essence to be sexually molested, so that the child thinks that this is somehow normal behavior. So again, part of the challenge that we always have in the criminal code is to make sure that it continues to respond to what takes place out there. As you know, this is an increasing problem. I hear this in my conversations with attorneys general outside of Canada, that the increase in this kind of activity on computers, and so our job as legislators is to try and make sure that our legislation is up to date and covers all as much of this activity as we can possibly get within the criminal code. So you'll see it's very wide-ranging and comprehensive. My colleague has some comments.
Just in respect to the issue of plea bargaining often has a bad reputation. Plea bargaining is absolutely essential for the operation of the justice system, and I say that as a Crown attorney. It's the abuse, as a former Crown attorney, it's the abuse of plea bargaining that we have to be mindful of. A principled Crown attorney will bargain or make an agreement if he believes that the public interest and the interests of justice can be served through another arrangement. And so that's essentially what a plea bargain or a plea arrangement is. What mandatory minimum sentences do is certainly encourage people to look at their alternatives. But what they also do is, once you go to trial and a person is convicted and receives the mandatory minimum, that individual is no longer back out in the street as quickly and then committing more offenses. So some say that it may delay the process because of additional trials. In fact, in the long run, these types of mandatory minimums properly focused on appropriate offenses such as these will in fact lessen the burden on the justice system.
30 seconds, short question, short answer.
We hear a lot from the opposition about the statistics on crime going down. Is that true when it comes to sexual offenses against children, Minister?
No, we might have missed that actually in the discussion, but the child pornography, the offenses against children actually are increasing. And I hear this in my discussions with my counterparts outside of Canada, that this becomes increasingly is becoming a problem. But a problem is a problem, and it's not just a question of statistics. We want to deal with these. I mean, it's the same way with drug crimes. I mean, drug crimes are up in Canada, but again, I always say we're not governing on the basis of statistics. I'm not bringing these forward because of the latest statistics we're becoming, because I believe they're the right thing to do to better protect children within the criminal law of this country. We should be making these changes, and we should, for instance, bringing in the 2 new offenses that I just outlined for you. I think it's important to do that, but you're quite correct. The incidence of these types of crimes is going up.
Mr. Stewart.
Thank you, Mr. Chair. I welcome the witnesses, and have to excuse me if I jump right to questions because my time is short. I'm mostly interested in questions regarding the Drug and Substances Act, Controlled Drug and Substances Act. My first question for Mr. Nicholson would be the 6 months for 6 plants aspect of this bill. I was just wondering, in terms of the size of marijuana plant, it says that it's 6 plants. It doesn't seem to be defined. Are you talking perhaps seedlings would be considered here?
Again, we rely on police, and it's a question of fact in each particular case. And since you've raised the 6 plants, it's the individual has to be in the business of trafficking. He's in the business of buying and selling these. But again, as you know, when these matters go before court, it's a question of fact in each case. And so
But, of course, the police would need some guidance on this. So will there be any guidance provided to police?
They do. They get guidance, as you know, from provincial attorneys general, Crown's attorney. They're the experts, quite frankly, and I've been very impressed in my meetings with them over the years. On the one hand, they tell me what a serious problem this is in terms of health and safety, and how this many times provides the currency for other harder drugs. So it is a big problem, and again, we're addressing it in this particular piece of legislation.
But it is possible that somebody could go to jail for 6 months for having 6 seedlings in a window box.
It's not just a question. He has to be in the business of trafficking in drugs, and I appreciate this, and I'm the first one, because I've introduced it 4 times. I appreciate my critics don't want to talk about that because, again, that kind of hurts the case against getting rid of the whole bill, but that is an essential part of that, and that has to be proven in every case.
Well, I'm happy to talk about trafficking, and I was just wondering how exactly you determine
Well, if you're happy to be talking about trafficking, we're on the same page,
okay,
because
that's nice.
what we're talking about in this bill here. This is good news.
But I would like to know how exactly you determine whether somebody is trafficking 6 seedlings.
You might get law enforcement agencies, and you can, they can tell you the things that they look for. I mean, it's becoming quite sophisticated. When I've been across the country, I've had these conversations with them, and they tell me, it's even changes within the business. They tell me, for instance, the grow-op business many times has moved outside the cities into the country where they feel they may be under less scrutiny. So there have been developments in that, but when you talk with law enforcement agencies, you'll be, I think, very impressed by how sophisticated and how expert they are becoming.
I just offer a very practical suggestion. If you want to learn a little bit about the law of trafficking, sit in on a provincial court or superior court trial. They'll explain the law quite thoroughly and the type of considerations that police make in determining it. These are very well-established principles. We're not changing those principles in any way.
Okay, my second question will be regarding recently the Supreme Court struck down an attempt to shut Insight, which is a safe injection site in the downtown east side. And I'm wondering, with imposing so many costs on the provinces, because most of these offences, mandatory minimums, will result in people going to provincial jails. I'm wondering if the government has explored the possibility of a charter challenge or a court challenge from the provinces in light of this offloading of expenses.
The provinces are very well aware of what we are doing. As I say, it's been at least 4 years ago that I introduced this bill before Parliament, and they have underlined to me what a problem drug trafficking is, within the provinces, and so again, they're well aware of this and the components of this bill. And as I say, this bill is identical to the one that died on the order paper and these particular provisions. And so, again, I appreciate the support that our provincial colleagues. I mean, it's been very helpful over the years, Mr. Chairman, in dealing with my provincial counterparts. For instance, getting rid of the 2-for-1 credit. They were unanimous on a couple of occasions, telling me they want us to move forward because they said that would free up provincial resources, that provincial courts were getting clogged by people who were continuously getting adjournments because they were racking up 2-for-1 credits. And so, again, we work with them, and they're well aware of this. And again, I've been very appreciative over the years of their support for our efforts to crack down on drug traffickers and other criminals.
Well, it's good we're talking about resources here because some people, since the estimates are not available to us, I've heard that as much as $20 billion is going to be downloaded in cost to provinces. Are you not worried about them challenging this constitutionally?
Well, I'd like to see that study. Could you table that one before?
I would hope you would have studies that you could show us.
I don't have that one, that's for sure. I mean, we look at the costs, and as I say, when I was here in the spring, we gave very detailed, and I had one question with respect to the drug offenses, and our estimate is that this will cost $67.7 million over 5 years. And again, these costs are reasonable, but if you've heard or seen studies that these things are costing $20 billion or $100 billion or whatever you have, I'd be
happy to trade studies with you.
Time is up, Mr. Woodward.
No.
Thank you very much, Mr. Chair, and thank you to both of the ministers. You're both
very articulate in explaining the provisions of these acts, and I want to thank you for that. I had the privilege of serving on this committee in the last Parliament, and I stand to be corrected, but if memory serves me, I think that our committee spent something in the range of 18 meetings simply studying what was then Bill C-4 and regarding young offenders. And we heard from quite a number of witnesses over a great many hours of testimony, and I was sometimes amazed at the things that witnesses came believing about this bill. For example, they seemed to think that we were taking out of the what used to be the or is the Youth Criminal Justice Act provisions regarding rehabilitation and reintegration and addressing circumstances underlying behavior. And yet, if you look at what we were doing and are still doing, I think all of those things are retained. So my question is for Minister Nicholson. Some of those criticisms were that the bill was focused more on punishing all young offenders rather than rehabilitating them. But my understanding is that Bill C-4 was responding really and targeting and focusing on the 5% or so of young offenders who were violent and repeat young offenders and who really posed a threat to public safety. There was those people, those very, if I may say, small number of young and violent offenders that were being targeted and focused by Bill C-4, and the balance, the rehabilitation and so on still remained. And I want to ask you, Minister Nicholson, if this is the same approach which is being maintained in the new Bill C-10 with respect to young offenders.
Well, thank you very much, Mr. Woodworth. I mean, you were very kind in saying we were articulate, but I don't know if we could be any more articulate than you just were about the provisions of this bill. This was very impressive, and again, you're very familiar with the sections that we are proposing to change. You're quite correct that the bill focuses on a relatively small number of young people who are a danger to the public, but a danger to themselves as well. And we have seen reports over the years that focus in on individuals who need help. They need some type of intervention, and the bill is very specific, and again, we want to increase people's confidence in the youth criminal justice system. We want to make sure that those individuals who, as I say, are a danger to the public and a danger to themselves get the kind of treatment that they need to protect themselves and the public. And so the bill is very targeted, very specific, and again, we have listened to what our provincial counterparts have said about clarifying certain areas. And so I would hope that in your study of this over the next few days that you will have an opportunity to hear that. But I mean, we're not doing some of the things that people have accused us of in the past. We're making sure that there are provisions that young people are not detained or not sentenced in the same facilities with adults. This came up, I think it was 2 elections ago, from a party that is no longer here. That being said, we put some clarification in, and these are very reasonable proposals. And but again, thank you for the excellent job that you did in articulating the principles behind it.
Thank you, Minister. And I want to say that, in fact, that canard about jailing young people with adults is still out there. I still read it, and I don't know who's promoting it. But I'm very glad that you've made the point.
Well, you can be assured that the Minister of Public Safety and I are not doing that.
I understand.
We're only saying what's in the bill.
Thank you very much. Do I have more time? 30 seconds. Minister, I just want to say quickly, we had a witness last time, a young man who actually spent a significant time in jail, came to our committee and confirmed exactly what you said about the benefit to him of having that sentence, and it really set his life on the right track. So thank you very much for that.
My pleasure.
Thank you, Mr. Woodward. Ms. Bork.
Yes, hi. So my first question is directed to Minister Taves. So I have many examples of criminals who have committed 3 minor crimes in a row and have been sentenced for 2 years of time, but they've actually been able to reform themselves. One particular example is a young gentleman who's actually been brought into a life of crime by his mother at the age of 11. And he has now reformed his life and is trying to be a carpenter, but he cannot because he cannot get what used to be a pardon, what will be a record suspension. So I was wondering if the minister has considered the social and economic costs to this problem of not being able to get employment for these reformed criminals.
Well, this would be news to me that someone who's been convicted of 4 indictable offenses, who's received a penitentiary term for each of those 4 indictable offenses, that he has somehow reformed himself and can't get a pardon. I would think most Canadians say that once an individual has been convicted of more than 3 indictable offences to which he or she has been convicted of the offence and sentenced to a penitentiary term, that individual should then be provided with a record suspension. There comes a point in time when society simply says, no, that's quite enough. Now, you might be mistaking what happens sometimes with a break and enter, for example. Let's say, even under this bill, a young person, and this is probably the case in the case where you're referring to, a young man has committed, let's say, 20 break and enters and has received 3 months consecutive on each, and then they do the rounding down or whatever they do, proportionality, and the individuals received 3 years. None of those offenses would count to the disqualification. None of them. So I'd like to see the particular case that you're referring to, because I find it surprising that those are minor offenses where a person has been convicted of 4 offenses for which he has received a penitentiary term on each offense.
Je serais contente de vous les donner. Aussi, c'est sûr que parler.
Well, you say that it's not possible that someone might reform after committing 3 indictable offenses. I'm thinking mostly of young people, somebody who's perhaps 20 years old, getting 3 offenses, 2 years apiece. He'd be 26 before he gets out. And then he has the rest of his life to reform, rehabilitate. I think perhaps you're forcing them into the criminal path.
The examples that you're referring to, because where an individual has been convicted of more than 3 indictable offenses for which of he has received in a penitentiary term in respect of each one, that individual should be deserving of a record suspension. I simply believe that there comes a point in time when society must be protected against that kind of an individual. And I believe we've drawn a very clear line. And I think it's a fair one. Canadians would agree with the position we've taken.
Ma prochaine question,
My next question deals with the international transfer of prisoners. Can the minister inform if he is aware of a letter that was sent to the American president in January 2010? Have you seen the letter? Are you familiar with it? And could we get could the committee obtain a copy of that letter?
I'll say it in English. If a letter has been sent if you're aware of a letter that has been sent from the American president to the Canadian, considering the criticizing actually the number of people that have been refused to transfer to Canada.
I haven't seen a letter from the president in that respect, but I can advise you this was an issue that I raised with the Homeland Security Secretary, Janet Napolitano, when I met with her and explained to her that in Canada, for example, people were receiving parole after 1/6 of the time, organized criminals, drug traffickers, of course, who receive substantive sentences in the state of Florida, in a federal penitentiary, there would receive a 20-year sentence. Of course, the lawyer wants them transferred here to Canada because they become eligible for parole after 1/6. in the United States, they serve 85% of their time in that federal penitentiary. And in my opinion, if these individuals have shown no inclination to reform themselves, and usually because they don't cooperate with law enforcement authorities, they specifically refuse to cooperate with law enforcement authorities as to indicate who their co-conspirators are in terms of these types of matters, we consider them a risk to public safety, and we choose not to bring them back. The Homeland Security Secretary was actually quite surprised of how lenient our laws are in respect of parole, and compared it then and offered that, you know, in the United States they wouldn't get parole. They don't get parole in the federal system. It's 85% you serve, and if you behave yourself, you get 15% off of that.
Mr. Rathgeber. Thank you, Mr. Chair, and thank you to both ministers and to your officials for your attendance here this morning. Minister Taves, sticking with the issue of International Transfer of Offenders Act, I recall in the last Parliament when this bill was before the committee, there was some criticism regarding the discretion that you as minister would receive in making decisions regarding the transfer of Canadians, repatriating Canadian prisoners back to Canada, which parenthetically I find ironic because other parts of this bill individuals criticize because allegedly judges are losing their discretion with respect to minimum mandatory sentences. But they seem critical of vesting more discretion in the minister with respect to international transfer of offender applications. And I was hoping you could elucidate this committee with respect to how that discretion will be used to protect Canadians.
Well, just on the issue of transferring prisoners, I note the comments of the opposition in the House saying how lenient the American system has become, that everyone now has done away with mandatory minimums in the United States, and that you know that it's become a virtual panacea to become a prisoner in the United States, which is always a surprise to me, given that every Canadian in an American prison wants to come home to a Canadian prison, and the reasons for that is very obvious. And you know, it's unfortunate that the opposition continues to mislead Canadians about how the sentencing laws and the lack of parole, for example, in the United States, or the mandatories that they serve, the sentencing guidelines, all of those kinds of things. We have a system that has been consistently focused on the interests of the criminal as opposed to the victims. And so what this law does, in fact, is create a number of criteria. The first criteria is that of public safety. Is the transfer of that individual from the United States back to Canada in the interests of public safety? And as the minister, that is what I need to consider. I have to say that the federal courts have given the Minister of Public Safety wide discretion in making that determination. A number of cases have been delivered by the federal court in the last little while. Some they have asked the minister to reconsider, and I think that, and I have reconsidered those, and ultimately the courts have upheld the decision that I have made in those cases on a reconsideration. But what this, in fact, does is give legal definition to the types of criteria that we have been applying. So in terms of the rule of law, these criteria are very important, both from an offender's point of view and from a decision-maker's point of view. And one of the things I like to stress is that if you want to cooperate with law enforcement officials, now that will be a clearly recognized criteria that you can point out and say, look, I identified who the ringleaders in this drug crime are, or who the ringleaders are in this child pornography crime. I have identified, I have demonstrated my willingness to be rehabilitated. But a Canadian incarcerated in a foreign prison shouldn't just be able to say, look, I demand to come back, and I'm not cooperating with law enforcement officials, and it's none of your business whether or not I'm considering being rehabilitated. So this gives clear definition. It corresponds to the rule of law, which I think is very, very important.
Thank you. Minister Taves, following up on a question from Mr. Stewart, I think one of the most underreported parts of the amendments to the Controlled Substances Act is with respect to the drug courts. And can you just clarify for me that an individual who has an addiction, if he or she deals with that addiction, how that person will be handled under amendments to this legislation? With respect to the drug courts?
There are provisions, as you've just enumerated, because it will allow an individual, in cooperation, of course, with the provinces and rehabilitation services, for an individual who has unfortunately become addicted and wants to do something about that, to get enrolled in treatment, and so that they could avoid then a criminal offense. And so, as I indicated, the bill, in terms of the penalties and increased penalties, deals with drug traffickers. At the same time, we as a government continue to support the concept of drug courts, which again allows an individual who's has unfortunately become addicted, not part of violence or organized crime. That's not what we're talking about. But the unfortunate individual has become addicted, to give that individual some hope to get off drugs and to get involved with a treatment program. So it's one of the provisions certainly that has my support, and one that I'm very enthusiastic about. Mr. Chairman, I appreciate we've run out of time, but in as much as a couple of questions were raised with respect to costs, I wonder if we could leave some analysis with you in both official languages. I appreciate much of it's just a repeat of what we said in the spring, but nonetheless, since the issue was raised, if we could leave that with you, then
thank
we appreciate
you.
it. So, thank you very much.
We'll distribute those. I want to thank the ministers and their officials for being here today, and I think we are just about right on time, and we need to adjourn for a few minutes.